Thank you. Good morning. It's Thursday, January 27th, 9:08 a.m. This is a meeting of Senate Natural Resources and Energy. We're continuing work today on Act 250 and S148, an act relating to environmental justice in Vermont. Our first witness had something come up, emergency come up, and it's canceled. So we have a little time on our hands. We can discuss where we are in Act 250, which I think is going to be helpful. And then at 9:30, the balance of the morning, we switch over to the S148 Environmental Justice Bill. And we will have a walkthrough of strike all, and we'll talk more about what that strike all is, where it came from, et cetera, when we get there. So on Act 250, the witness that was unable to join us was a lawyer who had a lot of experience on Act 250. So maybe we're missing that piece of the story at this point. But I want to take advantage of this moment and say, what are people thinking? So we have two bills, and Senator McCormick, I did tee up your bill yesterday a little bit in economic development and encourage them, if they were at all interested, to contact you directly to come in and talk with them.
Thank you,
so
Mr. Chairman.
You may hear from them. I don't know that we actually, Senator McCormick's proposed solution is not actually incompatible with the other one. You could say we would offer both, and people would choose their own adventure. Municipalities would choose their own adventure. That would be a little unusual, but I'm just saying I would say for myself, as someone who's been thinking so much about the smart growth enhanced designation, that I now have the sense that the additional ask, that the additional obligations that towns will have in order to gain that authority and relative independence from Act 250 is going to be so demanding that there'll be no takers. I think they'll say, what's the expression I hear these days? The juice won't be worth the squeeze. And I don't know that they're going to bother to get they'll go through the steps of taking it. So then we'll have a program that won't help anyone in essence. It'll be on the books and unused. And that's
are you talking about the exemption, or are you talking about the umbrella permit, or both?
No, I'm really talking about the the exemption. Basically, do Act 250 at the municipal level, and there's requirements in order to gain that level of independence. And my sense, particularly from yesterday's testimony, was that the people that we're offering this to are not interested in going down that path. And I get it. There's kind of this mess where we already have 5 different designations. Now we're talking about another designation that layers on top of it. So this is certainly not an Occam's razor approach to solving a problem. Senator Westman.
So I'm just going to throw this out there that for me, and it really isn't specific to Act 250, but from what these people I heard and what is disturbing to me is, if you are building a house and you build it in a place where they have already have water and sewer with the hookup fees versus doing a septic tank out on the countryside, and I may be, the numbers may be wrong. It kind of is, to me, it's just plain wrong that the hookup fees in the places that we want you to hook up are as much or more, can be as much or more than it is to build on the countryside. And that particularly for new development, not for existing stuff. You know, existing stuff that in an old farmhouse that's been there 100 years. I have a lot of sympathy for that. I've lived in one all my life. But for new development, shouldn't it be less expensive to build where there's infrastructure of water and sewer? And isn't that what we want?
Right. Well, I would say that's a very practical approach. You know, if we talk about sticks and carrots, reducing those costs would be, I was very surprised myself to hear how expensive. Yeah, I'd like to understand why the upfront cost is so high. I get it if someone's saying this is literally what it costs to hook up, but it sounded like between the two sets of fees they pay, that even when you're just connecting to a sewer system going past your house, you're paying something in the order of $20,000. And that's seems high.
I find that disturbing.
Okay. Yeah, me too. It was news to me. And so what's disturbing is also an opportunity, I suppose, if we make it less costly. Well, that was the thing we kept hearing over and over again. You know, if you're adding $5, $10, $15, $20,000 per unit, that's the difference between people moving forward or not sometimes. So, right. Senator McDonald, you've listened to these kinds of conversations for a while. Anything strike you as potentially promising?
Well, what surprised me about the testimony was the number of options we have made available for towns over the last 2 decades, and how few of those options have been welcomed and accepted. And I think it goes back to it's cheaper to build in the cornfields, and that's to build in the cornfields, to buy the cornfield and build. Once it's built, it becomes much more expensive in terms of having to build roads to get there, having to use carbon to commute. All those other long-term things are more expensive, but we in the legislature often kind of ignore future expenses to what's it going to cost me between now and Friday is what we try to sell. And sometimes the towns look past Friday and go, they look at the economics and they choose not to put those districts in place that would waive all the things that we say would be waived by.
Sarah McCormick.
Yes.
What's on your mind about this? I think Karen called it a Gordian knot. So
yeah,
we haven't found the sword.
I don't know if I have anything to add to what I've already said, and I don't want to sound like a broken record. I do acknowledge that developers say the permitting process is an impediment to the downtown development of affordable housing that we want. And maybe, okay, I guess I can add one thing, which is in terms of downtown. I have always envisioned downtown development as not just concentrated downtown, but if you need to build where there isn't open space already, you can only infill so much, that then you expand the village center rather than sprawling out in the surrounding countryside. And not to sound like too much of a local patriot, I acknowledge that Bethel, where I live, has a lot of problems. The downtown is kind of funky these days. But I think we've done what development we've had here, we've done right, which is to say the village is bigger than it used to be, as opposed to here's the village the way it was 100 years ago, and there's the sprawl all around it. We actually don't have that. Our new development has been adjacent to the village. So I think in terms of concentrated areas. As I say, you can only infill so much. But I do acknowledge that according to the developers, the permitting process is an impediment, too slow, too complicated, too expensive. And I think we do have to do something about that. And then it gets down, and now I'm going to be a broken record. We're down to, do you exempt or do you expedite? And I would like to keep it within Act 250. I think it's well conceived. The good old Vermont Republicans served this state well with Act 250. It's ironic, as a Democrat, I've dedicated my career to watching out for Republican legislation, but they did it right, and you give credit where it's due. And I would like to not abandon Act 250. If we can expedite the process within the confines, within the context of Act 250, I think that's a better approach.
Yeah.
I'm sucking up to Westman there with the Republican stuff.
I think I see a little tear in the corner of his eye.
Oh, yeah.
I don't know if people know this book, the Vermont Act 250 Handbook. It is now, it's the second edition, but it's quite dated. I think it's 1998. And it's given what we're struggling with, I thought you might find it interesting. I'm just going to read for like 1 minute from the foreword by Doug Costel, who was an EPA director under, I think, Carter, and then came up to Vermont Law School. So this is the foreword from this book. Act 250, Vermont's landmark land use regulation law, is nearly universally praised for its, so this was being written, 1998. You may not think that he could write this again right now, I'm not sure. Vermont's land use regulation law is nearly universally praised for its role in protecting Vermont's character and natural beauty. Since it was passed over 25 years ago, it has gained wide acceptance and respect. In the past, Act 250 has been criticized by those who feel the permit process has become too time-consuming. If indeed Act 250 does move slower than it should, there are several clear explanations. First and foremost, Act 250 is unique. It's not a court of law where trained attorneys argue their case for or against a permit application. It's not a bureaucratic regulatory process where engineers argue technical points with state civil servants. Instead, Act 250 was specifically designed to be different. Permits are reviewed by lay people who serve on Act 250 district commissions around Vermont. They are not government employees. They are local citizens who have agreed to spend time each week reviewing permit applications. Receiving only token payment for their work, commissioners must support themselves, like everyone else, through regular jobs. While some would argue that there's a faster way to run a permit process, few would say there is necessarily a better way. Any sluggishness in the process is outweighed by the benefits of having lay people make decisions within a decentralized system. Like democracy itself, the process often appears inefficient, but how many of us would be willing to trade it for something else? I'm almost done. In addition, the scope of issues which fall within Act 250 jurisdiction is broad. Act 250 goes beyond just looking at technical issues. It also looks at such difficult to define areas as aesthetics and how well a project conforms to local or regional plans. All projects alter the environment in some way. Act 250 is forced to decide just how much is too much. And I just thought that was kind of refreshing to read because we've been under siege for so long on Act 250 that for someone who understands it well and appreciates it, there's still a lot of good in it. And I don't want us to forget that, given that we're trying to find ways to keep moving. So I don't say that to lead to any big point other than just sort of putting a little something in the scales to balance out the negative remarks that are much more often apt to show up on our emails. The other thing I noticed in the last week of our testimony, and I'd like to come back to this, I think we talked about it a little, is strengthening the forestry provisions. That the housing piece, as important as it is, And it is important. It's taking all the air out of the room for talking about some other things that are important, and particularly for us, I think that means forestry. I've asked Mr. Fidel and Mr. Groveman at VNRC to help us think about that. I'm going to be looping back into Commissioner Snyder, but to revisit that section of the bill and see if there's more we can do, so that while we work on housing, we also make comparable progress on forestry, which has been languishing. Senator McDonald, I read that as a question.
I get myself into these things, but you can plan and do. I look at a marriage, and you got a lot of ways to deal with moving ahead here, and speeding things up for the sake of speeding things up is like telling the couple to go elope. And what could possibly go wrong? The whole marriage thing is a web of support that understands that that marriages have duration, costs. It puts together a general agreement that this is going to happen amongst families and such. And we're saying no. They should just be able to elope, and everything's going to work out fine. And meanwhile, we've talked about the balance between going downtown and taking care of the forests and the blocks of land and the wildlife corridors as being part of a greater community thing. And we're told, oh, trust us, let's just take care of speed this one up, and the other part we'll deal with later. Either you get everybody out of the forest fire, but you don't tell them you're going to take some out, and we'll come back for the rest of you tomorrow. And when we've tried to balance our Act 250 work, dealing with both goals that we've been told is important and there's a commitment to, that doesn't work. So you wonder how deep that commitment is, and are we being asked to deliver one half of the loaf and get the rest of the loaf sometime in the future?
Yep.
So I'm skeptical, and
Okay.
I'm not interested at this stage of the game watching my grandchildren elope. So,
Okay, well, I think one thing we can do is, we're yoking together any kind of changes on Act 250 related to housing with forestry. And I think that I have that concerns. I've talked to Senator Sorokin about that a little bit. I want to make sure that if they're doing housing related things, that they not take the wind out of our sails. I mean, if in some way we're negotiating, like, a desire on the part, particularly on the part of the administration, to move forward more rapidly on housing. And the thing that we're perhaps, but we're also concerned about at the same time, forestry. I think actually both parties are interested in both, but so I think they should stay together. I don't. Senator Campion, we haven't heard from you. I know you've been thinking about all this stuff from our conversations. Anything you want to share before we go back to our regularly scheduled programming on S148?
Well, my concerns with wastewater and communities and building up, improving that kind of infrastructure. And I'm always afraid that we're going to do things that are going to cause greater harm to the water systems and the rivers and the lakes, around our towns. So that continues to weigh on me. I've always said, if the automobile had been built 150 years later, I think we would be in a little bit of a better situation. Our downtowns would be maybe a little tighter. We wouldn't have, people having moved out. It would look a little bit more like a European feel, if you will. And so, but I do understand that, there are, I don't want developers and others to be deterred from good projects that would be downtown, that would prevent sprawl, that would help move us in the direction that I think a lot of people are moving in, particularly young people, which is, I'd say very young, and also I'm seeing older, moving downtown, being able to walk to coffee shops, being able to use public transportation. And there's definitely a shift out there. And I want developers to be able to have a level of predictability and move projects along without, I think, like all of us are saying, without any negative impacts on the environment.
Okay, so let me try to connect what I'm hearing you say with what Senator Westman was pointing out about, could we make an effective tool to help reduce the cost of hooking up to town sewer and water? And are you saying, but if we do that, we need to be mindful that we're not exacerbating a problem that relates to wastewater treatment plants putting things into streams and rivers?
Well, I think what you're seeing right now, and it would be interesting to hear from folks on this, is I think a lot of people are using I'm hoping, federal funds to update wastewater treatment plants. I mean, we know that these are serious situations that continue to be inadequate and cause pollution. So stuff might be happening out there that I'm not aware of that would make me feel more comfortable. Does that make sense?
Sure. Well, and I think
there's a gentleman in Rutland who's Westberg, maybe. He was with the Douglas administration. He's
Jeff Wenberg.
Wenberg, terrific. He seems to have a good understanding of what's happening out there as it relates to these kinds of things usually. But there might be others that are equally, if not better. So
okay, Senator Westman, and then Senator McCormick.
So just as a follow-up to Senator Campion, and I brought this up to the chair of the committee earlier this morning. There's like 3 or 4 sections in the budget adjustment this year that deal with water quality. One of the sections is $1 million to help people with failed septic tanks. We don't have a handle on, when you talk about village communities and overloading those systems, I think there's a number of places out in the countryside where there are failed septic systems, as many as there are systems in villages that we've got. And sometimes the systems in villages we keep better track of than we do a regular home out on the countryside. So there's a number of places right in the budget adjustment this year that are shoring up programs that we already have for those shortcomings, but those shortcomings are as much on the countryside with failed septic systems as they are with problems with sewage treatment plants in villages.
Okay.
Well, that's good to know. I mean, and I'm not, they all have to be fixed, but if you have, like a village of 17,000 people and one failed septic out in the countryside, there's a big difference between that and what potential pollution problems might be. So
I suspect there's more than one failed septic system out in the countryside.
You know what I mean, though. I mean,
I know exactly, but I would say in that larger community, there's people doing monitoring, and there's not always out on the countryside.
Yeah, no, I think that's fair. I'm just, the monitoring thing, though, that Senator Westman mentions, and this is in my own community, I need to loop to folks on, there's always seems to be a headline that, yes, it's being monitored, but what's being monitored is more crap ending up in our rivers. And I think all of these systems just need to be updated. And and looked at across the board. So I do appreciate that. And no, I recognize that it's money, money, money. But right now, people do have money and resources to do that.
Right. Well, this is a very perfect place for us to park a suspenseful conversation. Now, I'm teasing us a little, but it's an important thing, and there's an opportunity, and there's a bit of a choice about where to invest and go forward. So last word to Senator McDonald, and then Senator McCormick, and then we're going to move on to S148 because we have guests in the room.
We started out here a couple of moments ago with something about taking the wind out of our sails. We don't have any damn sails. We're being told to row. And really, we're dealing with downtown, and downtowns have TIFs to deal with this money thing, and the TIF is being bankrolled by the countryside. It doesn't get any TIFs, and you need to spend the money on the infrastructure if you're going to dump people downtown, and they don't just need the money to build. They need the coffee shops that the senator from Bennington says they want to walk to. They need to be able to live downtown without cars and big parking lots, and we want to do it on the cheap. And because we constantly telling ourselves in this time of limited resources, we're gonna look more and more like a third world country if we don't pay for the stuff that we think is important.
Sam McCormick, you're going to.
I'll try to be brief. To expand on the chair's comments that the downtown development component and the care for the forest component really are inseparable. What we're saying is we want to concentrate development here as opposed to there. That's the equation. And if we're just talking about downtown, we're not doing the full equation. And in terms of that concentration and that motion, I'm thinking of a comment from Jack Kerouac that invention is the mother of necessity. The senator from Bennington correctly pointed out the effect of the automobile on our development patterns. The automobile expedited sprawl. Once you have the sprawl, now the automobile is a necessity, because that's the only way you're going to get to the shopping mall. That's the only way you're going to get to where you're going. So we have to address both simultaneously, or because I think there are tremendous impulses still towards sprawl. And including, I know the young people, the hipsters like downtowns. I can't believe the neighborhoods in New York that no one wanted to go near 50 years ago that are now desirable hip places to live. Good. I mean, that's a good thing. I don't know if we can count on that particular demographic. I think there's a lot of Americans really still want to live on the countryside. And finally, another invention that is a necessity is the internet. And now we're right now having a meeting on Zoom instead of being in downtown Montpelier. The internet expedites sprawl development. And eventually, and it means now we need the internet for sprawl development. And if we have it, people build it and they will come. People are going to still be moving into the countryside. So we need to artificially, intentionally, aggressively protect the forest. And otherwise, just the downtown stuff is not going to do it by itself.
Okay. Well, good. I regret that our first witness had something come up that prevented him from coming. I'm glad we had the time to pause and think through some of the things we've been taking in testimony in the last week. So a conversation to be continued. Senator Westman?
Mr. Chair, I'll be away for a few minutes. I have some things that I need to catch up on for my afternoon committee.
Okay, great. And thanks for that heads up on BAA and the water stuff in there. You've opened up a whole interesting line of conversation about where are we investing in wastewater treatment and drinking water, and what are the consequences of those choices. Okay, So with that, we're going to change channels completely and go to S-148, an act relating to environmental justice. We've had testimony from various parties. A group, the group that presented last week to us put together a proposed strike all. And I worked with Ms. Chakowski. Frankly, I didn't feel like we were in a position to offer sort of our own consensus version, because we're still coming up to speed on what do we want to have in this bill. So with the most practical thing that could come up with was to ask Ms. Chakowski to accept, by and large, the suggestions we had from the working group, and Ms. Mahali led us through sort of a higher level bill summary of their proposal. That's now we're going to go through that. Ms. Chakowski's going to do a bill walkthrough. And I just wanted, so I'm being careful to say this is where we're starting, but everything in there, of course, like any ordinary bill, is open for discussion, negotiation, et cetera. I don't want anyone concluding that we've jumped from last year's bill to the current proposed strike all and we're done or something like that. So with that, I've also asked Ms. Chakowski to help us, because she's worked on this issue over the summer, et cetera, to help us be aware of where things that we would want to pay attention to are in this draft. So with that, Ms. Chakowski, good morning. Thank you for coming in. If you could walk us through the next version of S-148, please.
Sure. Good morning. Today posted on your committee page under my name is the strike all amendment. It's draft 1.1. And as Senator Bray just mentioned, it is based on language that was submitted. So I went through and tried to compare some of the differences. And so I'll point out some of the differences from the underlying draft as we go. So first, section 1 is a finding section. That is what the underlying bill as introduced also had a section 1. It is 7.5 pages of findings. So I'm not going to read through all of them unless you'd like me to. I will point out that many of them are the same as the underlying bill. However, some of them have been changed. Some of the language has been changed. Some of the findings have been removed, and some new findings have been added as proposed in the proposed draft. So you may want to ask your later witnesses why they did that. Yeah. Did anyone
Sure.
want me to read through the findings?
I'm thinking that I'm hopeful actually that senators have already read them, or they're certainly very readable. But let me just check in on findings, because at least while I've been on this committee, we've not included findings on the vast majority of bills. So I wanted to talk about two things, like what is eligible for being a finding? I mean, does it have to be, in a way, we're asserting here that this is what the committee has found. And so we haven't taken testimony on these 7.5 pages of findings. So I want to be cautious about just adopting 7.5 pages of findings. Do they, in general, if it's not testimony are most committees' findings direct testimony, do they arise out of direct testimony taken by the committee itself?
So findings are, to take a step back, you're right. The Senate doesn't usually use findings. They are discretionary. They're definitely not required. Findings legally are supposed to be demonstrable facts that you can point to a legal citation to. So all each individual finding should have a specific citation that I can include in the physical bill folder, so that there's a reference for what is being cited, and they're not supposed to be statements of opinion. Also findings, so that's why occasionally people want to include, elected officials, legislators may want to include things in findings that are actually more proper for a floor speech, or if they're trying, so it's important for them to be things that can be found and asserted and supported by a fact. They are used legally if the bill needs to have a legal factual justification with it attached to it. If, for example, the bill is controversial and it is strongly suspected that there will be litigation. So including language about the committee's findings and justifications based on the facts of why the bill is needed can be helpful if there's going to be a court case. We can talk further about that, because there is case law that suggests you want to be very careful in what you include in findings, because when a court considers it, they can both help or hurt depending on how the court interprets your use of language and findings.
Okay. So, well, thanks for that. And it's, I want to be aware of what the consequences of including these are. And I think when we have our later witnesses, then we can double back and just because I think in general, if we're going to include a finding, we'll want to have that sort of, we'll want to know that it's a demonstrable fact, and I think we'd want to have a citation, if not the direct testimony itself, in committee. Senator McCormick.
Yeah, I think you make a good point, Mr. Chairman, and Ellen has, I think, given important information that we have to think about. I would add that the findings leave us vulnerable on the floor to people who don't necessarily approve of the content of the bill, that they can cross-examine. That's a hostile sounding term, but that's what it is. They can cross-examine the reporter, challenging the reporter to substantiate the findings, and the reporter often is not able to do that. And we've seen that happen. There were particular colleagues of ours who are very good at that, and are perhaps not going to like this bill, and it leaves it very vulnerable to them on the floor. Thanks.
Well, so thank you for that. And for wherever we land in this, we'll make sure that we have the kind of data that would let either a reporter, well, first and foremost, really just ourselves, that we won't move anything forward in the bill that we're not confident of is a demonstrable fact. And that would put the reporter in a good position if challenged on the floor as well. Okay.
Right, and so the bill is introduced, did contain findings. And so the bill file does have some of the citations for what was already included. But because there have been changes in this draft, that will need to be updated.
Right. So I don't want to make too big a deal of it. I just want it to be, this is a break from our usual way of moving a bill, and a little bit at least. And so I wanted us to be mindful of the consequence. And with that, I think let's move into the section 2 and start reading the working sections.
Sure. So section 2 is adding a new chapter to Title 3, that's similar to what is in the underlying bill, but some of the sections that we'll see in a few pages are different. But the first section that's being added is the definition section. And there are some new definitions being proposed in this draft that were not in the underlying bill. So first, there is a definition of cumulative environmental burdens. So environmental burdens is defined later in the bill, and environmental burdens is definitely one of the more key definitions to this overall concept of environmental justice, and it's used in the state policy on environmental justice. This definition, so this is a new definition that wasn't in the underlying bill. So cumulative environmental burdens means the combined multiple environmental burdens on an environmental justice population or overburdened community, and shall be further defined by rule by the Agency of Natural Resources. So there's a few things here. First, this is being specific to cumulative environmental burdens being used in reference to environmental justice population, which is another defined term, and overburdened community, which is another defined term. So they're specific to those populations. But then, and I want to make sure that we remember that when it's used later in the bill, but also it's further defined by agency rule. From a stylistic standpoint, I usually recommend that committees define terms in statute. If an agency can further define a rule, a definition in rule without clear guidance, you could end up in a situation where the statute and the rule don't match, or has additional language that perhaps wasn't originally intended. So that's just something to consider. You can obviously have the agency further define it by rule, but you leave open the possibility of discrepancies.
Yeah, it struck me as novel. I don't know that I've seen a definition that then said there'll be further definition by rulemaking. Even though I know that happens, just the definition isn't self-sufficient, you know, no way. All right, so thank you for making us aware.
Okay, so definition number 2 is environmental benefits. And so as we'll see later when we look at the definitions of environmental justice, as well as the state environmental justice policy, environmental benefits and environmental burdens are the 2 key concepts. So this definition did appear in the underlying bill, but there are some small changes to it. Environmental benefits means the benefits that enhance the capability of communities and individuals to function and flourish in society, such as access to a healthy environment, clean natural resources, including air, water, and land, green spaces, constructed playgrounds, and other outdoor recreational facilities and venues, affordable, clean, renewable energy sources, public transportation, fulfilling and dignified green jobs, healthy homes and buildings, healthcare, access to nutritious food, including indigenous food and cultural resources, environmental enforcement, and training and funding dispersed or administered by governmental agencies. Environmental burdens. So again, this is in the underlying bill and it's a key concept here. This definition is quite a bit longer than it was in the underlying definition, and stylistically it feels unwieldy to me right here, and I think it's probably fine as drafted, or we could change it to make this more of a list, because what's happening here is there is a definition in the first couple of clauses, but then it does sort of list what environmental burdens include, what kinds of things are included in environmental burdens. So it is kind of difficult to read, but I'll read it to you now. So environmental burdens means any threat to the fundamental right to clean air, water, and land, including any destruction, damage, or impairment of natural resources that is not insignificant, resulting from intentional or reasonably foreseeable causes, including climate change. So I wanted to just stop right there and also add not insignificant. So impairment of natural resources that is not insignificant. We don't normally use double negatives. That was in the underlying bill, and so I think this is language that other states have used. But I think not insignificant is ambiguous. However, the clause immediately after it is actually really clear. So resulting from intentional or reasonably foreseeable causes, I think is actually more clear, and might not need the phrase not insignificant, or we could change, you could change it to significant, but that is just a stylistic suggestion.
Great. And I think so thank you. I think I'm just gonna, I'm going to, and I encourage colleagues to just flag things as we walk through so that we can come back to them. Thank you.
Okay, so further, air and water pollution, improper sewage disposal, improper handling of solid wastes and other noxious substances, excessive noise, activities that limit access to green spaces, indigenous food or cultural resources, nutritious food, or constructed outdoor playgrounds and other recreational facilities and venues, inadequate remediation of pollution, reduction of groundwater levels, increased flooding or stormwater flows, home and building health hazards, including lead paint, lead plumbing, asbestos, and mold, and damage to inland waterways and water bodies, wetlands, forests, green spaces, or constructed playgrounds, or other outdoor recreational facilities and venues from private, industrial, commercial, and government operations, or other activity that contaminates or alters the quality of the environment and poses a risk to public health.
Thank you.
So on to page 10, environmental justice. So this definition is the same as the underlying bill. And so did you want me to read through this one?
Yes, please, just because we really haven't done, we never did a walkthrough last spring since it came in so late. I think we just introduced the bill.
Okay. So environmental justice means all individuals are afforded the right to equitable access to and distribution of environmental benefits, proportionate distribution of environmental burdens, fair and equitable treatment and meaningful participation in decision-making processes, and the development and enforcement of environmental laws, regulations, and policies. And recognition of the unique needs of individuals of all race, color, income, class, ability, status, gender identity, sexual orientation, national origin, ethnicity or ancestry, religious belief, or English proficiency. Environmental justice redresses structural and institutional racism, colonialism, and other systems of oppression that result in the marginalization, degradation, disinvestment, and neglect of Black, Indigenous, and communities of color. Environmental justice requires prioritizing resources for community revitalization, ecological restoration, resilience planning, and a just recovery to communities most impacted by environmental injustices and natural disasters.
Okay. All right, thank you.
So that is, a very important definition. That is sort of what's underlying most of this bill. And as you saw right at the beginning, it does incorporate and use the defined phrases environmental benefits and environmental burdens. So next is a new definition that wasn't in the underlying bill, environmental justice population. I think actually in the underlying bill, there was directive for the advisory council to work on a definition of environmental justice population. But here, this is making it permanent in the statute. So environmental justice population means any census block group in which the median household income is not more than 80% of the statewide annual household income. People of color and indigenous peoples comprise at least 6% or more of the population, or at least 1% of the households have limited English proficiency. Limited English proficiency is a defined term further down on this page. Or an environmental justice population is a geographic portion of a census block group that meets at least one criterion of the above language I just read and is designated by the Secretary of A&R as an environmental justice population upon the petition of at least 10 residents of the geographic portion of a census block group. So basically 10 people can petition to have their area added as a environmental justice population. So a couple of things I wanted to point out. Up on lines 17 and 18, I think we may need to change the phrase here because I think what's actually calculated is usually state median household income. So just like a small tweak. And I did look up what 80% of the most recent data is, and I think it's approximately, it's somewhere between, I think, $49,000 and $50,000 annual income is the 80%. I did want to also point out that a census block group, because I did not know what this metric was. So in the US Census, a census block is the smallest unit, but a census block group is a group of census blocks. So it's the second smallest unit of data from the census.
And do you happen to know how many people you need to be a census block group, constitute a census block group?
I don't, because I think it varies by the size. Because I'm not a mapping expert. I think we could probably talk to, I think we might have someone with expertise on this, but I think I don't think it's based on number of people in an area. I think they're bounded areas and then they count the people within those areas. And so then a group is multiple blocks put together.
Okay.
But I am not an expert on this.
Right. Well, no, we don't. That's okay. Thank you. I'm just flagging it so we'll understand sort of how we're doing our counting.
Okay. So now I'm on page 11. Limited English proficiency means a household that does not have an adult who speaks English very well, as defined by the U.S. Census Bureau.
Can I ask a quick question before we go past that?
How about an English department?
The petition in B, just above, upon petition of at least 10 residents in a census block group. Do we have something similar to that you're aware of in law currently? You know, is there a process that this sort of plugs into? There's a petition, there's a process for hearing such a petition. If your petition is denied, is there a process for appealing the decision, et cetera? Is there already an apparatus to address that kind of thing, as best you know?
I don't think so.
Okay.
So yeah, that is, I hadn't thought about that. What would happen if a petition was denied? So that might be something to consider.
Okay. Thank you.
Senator McCormick, Senator McDonald, was that a rhetorical question? Because I think that
I don't know. We're debating. I don't know what we're talking about here.
So this definition.
I'm frustrated. We're the Natural Resources Committee, Mr. Chair, and we're discussing the vocabulary about what? We're not doing anything. We're not. This is. I'm astounded that. Yeah.
You want to explain, Senator Bright, why we're doing this?
Yes. So, Senator, I'll start with an analogy. They worked on the State House in the past year, and they spent a tremendous amount of time building scaffolding outside the State House so they could do the work. We are doing the scaffolding right now. It's like we have to have a language to work with in order to address the issues that affect people, and it affects them in lots of different ways. So we're looking at them from all sorts of cultural aspects that we wouldn't necessarily talk about directly in this committee, but in the end, those definitions are going to flow through to real life decisions at ANR and elsewhere. V-Trans, about where does a new road go? What's happening on water quality? What kind of remediation choices are made? So we need, it is different for us, but it's because we're getting into the world of talking about who our constituents are and being able to understand their needs better. That's what I would say.
Well, we have all sorts of laws that tell us what we ought to do, and then we say notwithstanding, or we carve something out, we don't do it. So why don't we do some of the things that we're not doing instead of talking about how promising that we're going to do them in the future after we get the vocabulary right in the promise? We're not doing any of those things.
Okay, well, I would say we have a mixed record of doing, right? And A&R is with us here today, and they would be the primary implementer of this. So I'd say as we work on this, I would invite you to flag any major opportunity that we're failing to deliver on because we've not withstood something, for instance. And I'm definitely not interested. I don't think anyone's in, I'm sure no one is interested in just creating a new program, a new language, a new construct to check something off. We actually want to make meaningful progress. So where you see us having failed to make meaningful progress in the past because we exempted something, not withstood it, then let's bring that into the room for discussion as well. So thank you for that. And I can understand.
Thank you for indulging me. I will, I'll mute myself. Thank you.
Right, and I was just going to add that limited English proficiency is going to, play into it, especially the next section, which is on meaningful participation, which is another sort of underpin. Meaningful participation is a very important aspect of environmental justice. So requiring that the state agencies provide an opportunity to all individuals, including those with limited English proficiency, to meaningfully participate, which is difficult if government documents are all in English. So meaningful participation is defined here. It's the same as the underlying bill, but I will read it to you. Meaningful participation means that all individuals have the right and opportunity to participate in energy, climate change, and environmental decision-making, including needs assessments, planning, implementation, permitting, compliance and enforcement, and evaluation. Meaningful participation also means that Indigenous communities with diverse knowledge, systems, histories, traditions, languages, and cultures are integrated in decision-making processes. Communities are enabled and administratively assisted to participate through education and training, and communities are given transparency by the state government with regards to opportunities for community input and are encouraged to develop environmental, energy, and climate change stewardship. So along with environmental burdens and benefits, this is one of the other major definitions in this, and it's a significant part of this program that's being established. On to page 12, overburdened or underserved community means a geographic area that is defined pursuant to a rule promulgated by the Secretary of A&R and based on the environmental justice mapping tool established, which we'll talk about in a minute, and the funding reports generated pursuant to the next section. An overburdened or underserved community does not have to meet the criteria for a designated environmental justice population. So this is an unusual definition for me. The phrase overburdened or underserved community is used later in the bill. It is sometimes used in conjunction with environmental justice population, but it is different. But what stands out to me is that this is a defined term that is just saying that it is going to be defined by A&R, which is unusual. So it doesn't actually have a definition here. All right, so now we're out of the definition section. And Environmental Justice State Policy, Section 6002. It is the policy of the state of Vermont that no segment of the population of the state should, because of its racial, cultural, or economic makeup, bear a disproportionate share of environmental burdens or be denied a proportionate share of environmental benefits. The following state agencies shall consider cumulative environmental burdens as defined by rule pursuant to Section 6003 and access to environmental benefits, which making environmental benefits when making decisions about environment, energy, climate, and public health projects, facilities, and infrastructure, and associated funding. The agencies of transportation, commerce and community development, agriculture, food and markets, and education, and the departments of health, public safety, and public service. It is further the policy of the state of Vermont to provide the opportunity for meaningful participation of all individuals with particular attention to environmental justice populations and overburdened or underserved communities in the development, implementation, or enforcement of any law, regulation, or policy. So that is what this bill is really talking about. This is another really important section of this bill. It's establishing the statewide policy on environmental justice. It's also making specific directives to the state agencies that they have to consider the cumulative environmental burdens and environmental benefits when they're making decisions. And meaningful participation is required for all people.
So this is really going back to the federal law. If you're receiving, I mean, it's the foundation for all this, that the federal law says that if you're receiving federal funds, you have to have a non-discriminatory process. And so are we saying in this, we're proactively working, and we need to do it across all these different agencies to have a process that engages those communities?
I think you should ask.
The process in and of itself could be discriminatory otherwise.
I think you should ask the other witnesses this question, but I think the answer is no. I think this is very specific to environmental justice. The next section addresses the Title VI concerns. So I think they are related. So the answer is I really don't actually know if that's the right answer. So I think there is specific language in the next section about Title VI and community engagement plans.
Okay, thank you.
So on to page 13, as I just mentioned, on or before July 1, 2024, every Vermont state agency shall create and adopt a community engagement plan that describes how the agency will engage with environmental justice populations and overburdened or underserved communities as it evaluates new and existing activities and programs, taking into consideration the recommendations of the Advisory Council on Environmental Justice, which we'll talk about in the next section. The plan shall describe how the agency plans to facilitate equitable participation and support meaningful and direct involvement of environmental justice populations and overburdened or underserved communities in compliance with Title VI of the Civil Rights Act of 1964. So this is slightly different than what we were just talking about in the last paragraph. Next, every state agency shall submit annual summaries to the Advisory Council on Environmental Justice, detailing all complaints alleging environmental justice issues or Title VI violations, and any agency action taken to resolve such complaints. Agencies shall consider the recommendations of the Advisory Council pursuant to 6004 and substantively respond in writing if an agency chooses not to implement any suggestion within 90 days of receipt of recommendations.
Okay. Any questions for council? All right, please continue.
All right. I'm now on page 14. And this is all new it's different from the underlying bill. And so Yeah. The state shall spend at least 55% of environmental, renewable energy, climate mitigation, transportation, and climate resilience funds in designated environmental justice populations and overburdened or underserved communities, provided that those funds are not already reserved for certain populations that meet eligibility criteria. I don't know what that last clause means. I don't know what reserved for certain populations that meet eligibility criteria means. Does that just mean everyone else that isn't in these types of communities? Yeah, I would need clarification. I think the sentence would make sense potentially without it, but we might want to check on this.
Okay, thank you.
Yeah, I'm not an expert on funding. So I haven't looked into the issue of whether or not this would conflict with any of the requirements of special funds. But that may be something you may want to consult with either. I suspect the Appropriations Committee would be interested in reviewing this section.
Okay, thank you.
So next, on or before December 15, 2022, the Agency of Natural Resources and Transportation and the Department of Public Safety and Public Service shall report to the General Assembly the percentage of funding for the last 3 years that have been spent in communities where some portion of the community is designated as an environmental justice population or overburdened or underserved community, as defined in 6001. So I know what this language is trying to do. It's asking these agencies to look back in their last 3 years' budgets and report how they have already spent money in these communities. However, I did want to point out that, as I mentioned before, overburdened and underserved community is not yet defined. So I think that would be difficult unless A&R does a definition before the end of the year. So maybe it will be. But I also, so on lines 9 and 10 here, spent in communities where some portion of the community is designated. Community itself isn't defined. I'm wondering if it's supposed to be municipality or if it goes back to the term census group block. So I think this is a little bit vague and it may need to be just clarified slightly.
Okay.
On or before December 15, 2023, and annually thereafter, the Agency of Natural Resources and Transportation and the Departments of Public Safety and of Public Service shall issue reports that detail how environmental justice criteria were used for awarding grants and prioritizing program funding for the prior fiscal year. The report shall show at the census block group level the amount of public funds or publicly leveraged funds used and for what projects. So again, that's a reporting on how the implementation of this environmental justice spending program is going.
Okay. It also occurs to me that it could be helpful maybe to tie this to who at the legislative level should receive and review those reports so that they become useful to everyone. But let's keep going. Thank you.
All right, on to page 15, rulemaking. Within 1 year of the effective date of this act, the Agency of Natural Resources, in consultation with the Advisory Council on Environmental Justice and the Interagency Council on Environmental Justice, shall adopt rules to define and implement consideration of cumulative environmental burdens as required under 6002. Within 6 months of the publishing of the environmental justice mapping tool, The Agency of Natural Resources, in consultation with the Advisory Council on Environmental Justice and the Interagency Council on Environmental Justice, shall adopt rules to guide how the public and state agencies shall use the mapping tool. So we haven't gotten to this section yet, but this bill does require the creation of an environmental justice mapping tool. So this is directing that there be rules on how the public and state agencies will use that. The Agency of Natural Resources, shall incorporate the principles of the environmental justice state policy into rules and guidance where applicable. The agencies of transportation, of commerce and community development, of agriculture, food and markets, and of education, and the departments of health, public safety, and of public service, in consultation with the advisory council, shall adopt or amend policies and procedures, plans, guidance, and rules where applicable to implement this chapter. And I did just want to point out that neither of those last two sections have a date requirement by, which is fine, but you might want to consider that by when they need to update their rules.
In line 13, the environmental justice state policy, is that already fully defined, or okay? I didn't know if it's subject to further modification.
No, it's subsection A of 6002.
Okay, thank you.
Yeah, so the environmental justice state policy is specifically provided for in statute. It's then the requirement that all the agencies implement it and bring it into their agency policies and procedures.
Okay, thank you.
All right. On to page 16. The Agency of Natural Resources, in consultation with the Advisory Council on Environmental Justice and the Interagency Council on Environmental Justice, shall review the definition of environmental justice population every 5 years and recommend revisions to the General Assembly to ensure that the definition achieves the environmental justice state policy. Any proposed rules and access to the detailed record required pursuant to this section shall be provided to the Advisory Council on Environmental Justice not less than 45 days prior to submitting the proposed rule or rules to ICAR. Not more than 25% of the members of the Advisory Council on Environmental Justice, if more than 25% of the members of the Advisory Council are opposed to any proposed rule as determined by vote, the relevant agency must reconsider the proposed rule and prepare a revision that responds to member concerns. Okay, so that last section directed that the agencies need to adopt rules to implement the environmental justice policy. Before they update their rules and submit them to ICAR, 45 days before they submit them to ICAR as part of the rulemaking process, they need to submit the rule to this new advisory council that's going to be created in the next section. It then says that if more than 25% of the members vote against the rule, they have to revise the rule and respond to member concerns. So I think that this stylistically could just be switched around to say that a proposed rule requires a supermajority of voting members of the advisory council in order to approve it. Otherwise, they need to respond. I think that's how it is normally phrased when you do rules, but I mean, it's fine. It just stylistically reads a little weird.
Right. I mean, I don't think I've ever seen sort of empowering a minority to object. It's usually you have to win a supermajority to move forward or something like that. Okay. The phrase in line 7, access to the detailed record.
Yeah,
is that adequately clear what records we're talking about to you as a drafter?
I think that could be clarified slightly. I think what it's asking is that that an agency basically submits the full record they would normally submit to ICAR and LCAR as part of that process. Although I'm not 100% sure. I did find that phrase to be a little awkward.
Okay.
But so I think that's what the intent is, though, is to make sure that they have the full rule packet that would normally be submitted when a rule is going through the process.
Okay. And I'm just thinking about how this could play out on the sort of the supermajority requirement to reap the consequence of not gaining the right level of support is that you end up, the agency must reconsider the proposed rule and prepare a revision that responds. Well, I mean, it seems as though you could get permanently stuck there if the agency never delivers a version that wins a supermajority. But maybe that's built into many things we do. There's no inherent certainty that you resolve this, I guess is what I'm thinking of, but maybe that's fine.
Maybe. I think, yeah, there are some intricacies with rulemaking where, yeah, rulemaking can be tricky. It does have sort of a defined schedule in the statutes, but different input, depending on the level of input from the community or the complexity of the issues, it can take longer or shorter depending on what's going on. So, yeah.
Okay, well, thank you. I think in part because Senator McDonald and I are both currently on LCAR, very sensitive to seeing how rulemaking gets used, defined, et cetera, deployed. Okay, so thank you. I guess we can go on to the next section. I don't see any questions from the committee.
Okay, so section 6004 establishes the two bodies I've been referencing, the Environmental Justice Advisory Council and the Interagency Council on Environmental Justice. Within 90 days of the effective date of this act, there is created an Environmental Justice Advisory Council to provide independent advice and recommendations to state agencies and the General Assembly on matters relating to environmental justice, including integration of environmental justice principles into state programs, policies, regulations, legislation, and activities, and an interagency council on environmental justice to guide and coordinate state agency implementation of the environmental justice state policy and provide recommendations to the legislature for amending the definitions and protections set forth in the chapter. Both the Advisory Council and the Interagency Council shall consider and incorporate the guiding principles for a just transition developed by the Just Transition Subcommittee of the Vermont Climate Council in their work and strive to create and maintain equitable dynamics within the culture and operations of the councils.
Okay. I'm going to flag that last phrase as needing further definition. For instance, equitable dynamics, but we'll ask, we'll learn. Thank you.
Meetings. The Advisory Council and Interagency Council shall meet at least 4 times per year with at least 2 meetings occurring jointly. So either body shall meet 4 times per year and they will meet together at least twice. Duties. The Advisory Council and the Interagency Council shall jointly, within 1 year of the effective date of this act, consider and recommend to the General Assembly whether more inclusive thresholds and additional criteria should be used or should be added to the definition of environmental justice populations, including populations more likely to be at higher risk for poor health outcomes in response to environmental burdens due to adverse socioeconomic factors such as unemployment, high housing, transportation, and energy costs relative to income, limited access to nutritious food or adequate health care, linguistic isolation, and other factors that negatively affect health outcomes and increase vulnerability to the effects of environmental burdens, and sensitivity factors such as low birth weight and higher rates of hospitalization, and examine existing data and studies on environmental justice and consult with state, federal, and local agencies and affected communities regarding the impact of current statutes, regulations, and policies on the achievement of environmental justice. The Advisory Council shall advise state agencies on environmental justice issues and on how to incorporate environmental justice into agency procedures and decision-making as required in 6002, and evaluate the potential for environmental burdens or disproportionate impacts on environmental justice populations as a result of state actions and the potential for environmental benefits to environmental justice populations. The council shall advise state agencies in the development of community engagement plans and approve each agency's plan by majority vote. On to page 19. Advise state agencies on the use of the environmental justice mapping tool established in section 6005 in the enhancement of meaningful participation, reduction of environmental burdens, and equitable distribution of environmental benefits.
Sorry, my mind is working a little more slowly than you're reading. I have a question that occurred for lines 19 and 20 on the preceding page, page 18. So that advisory council advises the state agencies, but it also approves their plan by majority vote. So I'm just unaware of if we have advisory boards that have that sort of authority over the plan of an operating area of government. That, like, I don't know whether I've seen that we have citizens approving of plans, otherwise government can't move forward when it's, anyway, it's, I'll just flag it and say, it seems like a novel construct, and I understand the concept, but I'm not sure of the legal footing that it's working, that it's based on, just as a construct. Am I missing something? And you say, oh no, we do this all the time. Consider X, Y, or Z.
I don't have any examples off the top of my head, so I don't know.
Okay. So again, I'll just put a flag on mine. Thank you.
Right. So I was on page 19. Okay, line 5. Review. So still in the duties of the advisory council. Review and provide feedback to the relevant state agency on any proposed regulation implementing this chapter. So that actually should probably be proposed rule. Receive and review state agency summaries of complaints alleging environmental justice issues, including Title VI complaints, and recommend options to the state agencies for the resolution of complaints. Membership. Advisory Council. Each member of the Advisory Council shall be well informed regarding environmental justice principles and committed to achieving environmental justice in Vermont and working collaboratively with other members of the council. To the greatest extent practicable, Advisory Council members shall represent diversity in race, ethnicity, age, and gender, urban and rural areas, and different regions of the state. The advisory council shall consist of the following 15 members, with a significant number residing in environmental justice populations. The director of racial equity or designee.
Right. So I'm flagging significant, like whenever an adjective goes floating by like that, I don't know what we mean by it. Thank you.
Onto page 20. One representative of municipal government appointed by the Committee on Committees. 2 representatives of a community affected by environmental justice concerns. 1 appointed by the Committee on Committees, 1 appointed by the Speaker of the House. 2 representatives of social justice organizations, 1 appointed by the Committee on Committees and 1 appointed by the Speaker of the House. 2 representatives of organizations working on food security issues, 1 from the Senate, 1 from the House. 2 representatives of mobile home park issues, 1 from the Senate and 1 from the House. 2 representatives of a state recognized Native American Indian tribe recommended and appointed by the Vermont Commission on Native American Affairs. 2 representatives of immigrant communities in Vermont, 1 from the Senate and 1 from the House. 1 representative of a statewide environmental organization appointed by the Speaker of the House. The Interagency Council, now I'm on page 21. The Interagency Council shall consist of the following 9 members. The Secretary of Administration or designee, the Secretary of A&R or designee, the Secretary of Transportation or designee, the Commissioner of Housing and Community Development or designee, Secretary of Agriculture, Food and Markets or designee, Secretary of Education or designee, Commissioner of Health or designee, Director of Emergency Management or designee, and Commissioner of Public Service or designee. The Advisory Council and the Interagency Council may each elect 2 co-chairs and may hold public meetings. Yes. After initial appointments, all appointed members of the Advisory Council shall serve 6-year terms and serve until a successor is appointed. The initial term shall be staggered so that a third of the appointed members shall serve a 2-year term. Another third of the appointed members shall serve a 3-year term, and the remaining members shall be appointed to a 6-year term. I wanted to just point out that this was kind of it seemed like an odd staggering to me because it's 2-year, 3-year, 6-year.
Right.
But
Right.
that's not a problem. It's just an interest. It's just us. You might want 2 or 2, 4, 6 or 1 through 6. On to page 22. So we're almost done. Vacancies of the Advisory Council shall be appointed in the same manner as the original appointments. The Advisory Council shall have the administrative, technical, and legal assistance of A&R. The Secretary of A&R shall implement recommendations of the Advisory Council to the extent they are consistent with this chapter. Members of the Advisory Council who are neither state nor municipal employees shall be entitled to per diem compensation and reimbursement of expenses as permitted under 32 VSA 1010. Oh, sorry, I did want to go back to subdivision 7 on lines 5 through 7. So Secretary of A&R shall implement recommendations of the council to the extent they are consistent with this chapter. I'm not really sure what consistent with this chapter is trying to say. So it sounds like it's discretionary that the A&R can implement recommendations, but might want to clarify this language a little bit.
Okay. I'm also uncertain as to whether or not that implies A&R has the ability to have other operating areas implement because we talk about other agencies, for instance, in the council. And is this implying that they have some authority or responsibility to implement recommendations in V-Trans, for instance? I don't know. So we'll just have to work on that language, get it clear. Okay, thank you.
Okay, and then finally, the environmental justice mapping tool. In consultation with the Advisory Council on Environmental Justice and the Interagency Council, ANR shall determine indices and criteria to be included in a state mapping tool to depict environmental justice populations and measure environmental burdens at the smallest geographic level practicable. The Agency of Natural Resources shall maintain the mapping tool. I think you heard a little bit about this the other day, but there is a federal mapping tool that I think I'm going to mention in the next section. So there's at least an existing model for this at the federal level, and some other states have already created mapping tools as well. ANR may cooperate and contract with other states or private organizations when developing the mapping tool. The mapping tool may incorporate the federal environmental justice mapping tool, EJ Screen, as well as existing state mapping tools, such as the Social Vulnerability Index. On or before January 1, 2024, the mapping tool shall be available for for use by the public as well as by the state government. And so this tool will be important to the other work required by this bill, including determining where the funding will be spent. Yeah. All right, page 23, section 3, annual report. Beginning July 1, 2023, the Agencies of Natural Resources, Transportation, ACCD, Agriculture, Food and Markets, Education, Departments of Health, Public Safety, and Public Service shall issue and publicly post an annual report summarizing all actions taken to incorporate environmental justice into the agency's policies or determinations, rulemaking, permit proceeding, or project review.
So I'm just going to flag for myself that this annual reporting requirement here in section 3, and we saw an annual reporting requirement back on page 14, and want to sync those things up. I don't quite.
Yeah, you may also want to put it in the statute since it's an annual permit. It's a permanent annual report.
Okay, thank you.
Finally, section 4 has a placeholder for funding. And then the effective date is effective on passage.
Are you aware of anyone in the legislative branch who's done any kind of work on being able to start filling in section 4? Is JFO analyzing this, or I don't know if there was any kind of fiscal note requested last spring on the original bill, for instance.
Oh, I don't know. I know the JFO is undertaking their large climate action plan assessment of what. So the answer is I don't know. Okay. I don't know. They might have started one. I'm not sure.
Right. Okay, great. And since there is a relationship to the work in the climate action plan, be helpful to make sure that we look at the climate action plan and see how it flows into this and vice versa. Okay, great. Any committee questions for council? Okay.
Thank you.
Any last remarks from council? Not last remarks. Any remarks from council to us about something you want to have us aware of beyond just having gone through the bill with us?
No, I was just going to follow up and say this draft only became public this morning because I only just finished it. So if JFO did a fiscal note, it would need to be updated anyways, because this language is significantly different than what was in the underlying bill. The underlying bill really only just created the advisory bodies and asked them what the next steps should be in developing the environmental justice policy. So there, it might have also included the mapping tool, but it was a little more limited than what is in this draft.
So thank you for that walkthrough, and we're running a little behind schedule. So what I'd like to propose is that we just take a 10-minute break and then start at 10:55 and jump back in so that everyone's had a little break before, rather than just plowing on through. We have a lot to do. And then I also just want to say, for anyone who's watching elsewhere, as we ask detailed questions of our council and the guests who are coming into committee to talk more about this, it may seem as though I just want to make sure that as we work and edit carefully, there's nothing negative about that. Sometimes I think when people see editing underway, they think you're picking on a bill, and this is not in any way picking on the bill. This is us doing our due diligence, and the goal is to write as clear and strong a bill as possible. So I'm just offering that by way of explanation. All right, so it's 10:44. Let's reconvene at 10:55. Thank you, Ms. Chakowski, and we'll go next to our A&R colleagues to hear their thoughts on the language